In recent years, society has gradually shifted its opinion towards the controversial topic of same-sex rights. However, its beliefs and ideas may still be considered unacceptable to the majorities of the world. Leading nations such as the United States, New Zealand, Canada, France, Germany, Ireland, Netherlands, and in recent Australia have taken a stand to support the rights of the lesbian, gay, bisexual, and transgender community. These rights ensure that the LGBT community are given personal autonomy, freedom of expression, and association to live in our society without discrimination. One controversial right follows the prospect of same-sex adoption. After careful consideration by all states of Australia, the right to adopt as same-sex couples was officially approved as of March 2018 under the Lesbian and Gay Reform Adoption Act Amendment 2017 and the Family Law Amendment 2018. However, although current legislations do indeed recognize same-sex adoption, the legislation has not been tested and is not fully established. As a result of this, current legislation is ineffective in balancing the rights of same-sex couples who seek to adopt. Hence, current legislation recognizing the right of same-sex adoption has failed in balancing family relationships and well-being. Ultimately, legislative reforms must be undertaken to ensure that the family law upholds certain rights and obligations which apply to family members across Australia. The right to adopt as same-sex couples within Australia have been a contentious debate throughout the last decade. In the early years, same-sex couples were deemed as unfit to adopt a child. Despite heavy opposition by the LNP party and after much debate in the state parliament, it was decided that balance must be struck when considering the rights of same-sex couples in relation to adoption. As a result, by 2002, Western Australia and ACT had become the first states to successfully allow same-sex couples to register for adoption, followed by New South Wales in 2010, Tasmania in 2013, and Queensland in 2016, South Australia in 2017, and Northern Territory in 2018. By expanding and opening adoption eligibility to same-sex couples, it provides a wider and richer pool of people that can provide better and loving homes for the children. Heavy objections were made by the LNP party, where spokeswoman Ross Bates argued that there is no demand, so that there's no need to expand the eligibility. However, Queensland's Minister for Communities, Women and Youth, Shannon Fentiman, fired back stating, "It's a matter of fairness, a matter of removing unfair discrimination." The notion of passing same-sex adoption in all parts of Australia marked a historic move to further push for LGBT rights. This reform in legislation successfully impacted the LGBT community, encouraging more couples to seek adoption as their first choice when considering parenthood. This motion provided children with more opportunities and selections of homes that truly welcomed them. However, despite the passing of same-sex adoption, very few are successful. The passing notion of same-sex adoption opens the gateway to opportunities for not only the LGBT community, but the children and their agencies. By legalizing same-sex adoption, not only does it provide options for families facing biological difficulties, but also expands upon a richer pool of prospective parents that can provide permanency and stability for children within the childcare system. This ensures local adoption becomes first choice over surrogacy and international adoption. As a result, children who are assigned to these families will feel loved and welcomed. This also greatly benefits the healthcare system, as according to statistics from the Australian Institute of Health and Wellbeing Report 2015, of the $155 billion spent in 2013 to 2014, $145 billion was recurrent health expenditure, which includes the expense made towards managing the childcare system. Hence, by legalizing same-sex adoption, there will be more interest in adoption, and as a result decrease the amount of expenditure needed to be spent per year. However, despite these benefits, Australia currently still struggles to find balance within its family law. Hence, it is necessary for reforms to be undertaken to ensure the best interests of all stakeholders are considered. The Family Law Act 1975 has been the governing law which covers parentage for families across Australia. In theory, adoption is a strong solution which can assist same-sex families facing biological difficulties in becoming birth parents. However, flaws within the family law makes it extremely difficult for these couples to successfully adopt. No laws in Australia currently ban same-sex couples from adopting. However, this does not mean that the law protects them from discrimination when coming on the topic of adoption. In addition to this, adoption in itself is generally rare as the process is complicated, with each state and territory having their own rules and regulation. In an interview with Huffington Post in 2016, Renee Carter, CEO of Adopt Change, stated, "Adoption rates in 2015-2016 were at an all-time low, and we're not talking a couple thousand, we're talking 278. With the rate of adoption in the first place being as rare as it is, the chances for a successful adoption by same-sex couples have have been described to be near impossible. This is due to the legislation ineffectiveness in addressing the sensitivity of social, cultural, ethical and moral values within Australia. Exemptions for religious bodies under the Equal Opportunity Act 2010 permits religious organizations to discriminate based on religious beliefs, sex, sexual orientation, lawful sexual activity, marital status, and parental status. As a result, many religious adoption agencies appeal for legal provision to refuse LGBT applicants. Hence why current legislation is ineffective, as many religious organizations receive government funding to provide services and yet are still able to discriminate against the LGBT community in relation to certain services. Therefore, it is without a doubt that current legislation has failed in practice to acknowledge the right of same-sex couples wishing to adopt. Such exemptions undermines the human rights of equality and protection against discrimination legislation such as the Australian Human Rights Commission Amendment 2012 and Sex Discrimination Amendment 2013. Under these anti-discrimination reforms, it is classified unlawful to discriminate against a person on the basis of sexual orientation under Australian federal law. Same-sex couples are to be protected from discrimination under the definition of marital or relationship status. Consequently, by denying access and services towards potential parents that are of same-sex orientation, it can be seen as negligence by the federal law for not correctly reinforcing their policies. In addition, it can also be seen as a breach and violation of current anti-discrimination laws. Therefore, reforms must be made in order to successfully reinforce and promote balance within Australian family law. Restrictions to same-sex adoptions can be seen in 2015 when Victoria's Upper House passed legislation to legalise adoption by same-sex couples, however with an exemption for faith-based adoption services. According to Victorian Minister for Equality, Martin Foley, in an interview with ABC, in the delivery of state services, the Liberal Party voted to continue allowing discrimination against same-sex families and their children. The passing of this exemption was to relinquish parents in adoption and give them the right under the Adoption Act to make sure their children go to the families and circumstances they wish for. As a result, this bill passed the Upper House 31-8. Victorian Director Dan Flynn from the Australian Christian Lobby said that the introduction of exemption was a great win for diversity, stating, "I think that it's been a significant stand by the Coalition for Freedom of Faith generally, and I think an acknowledgement that we can have multiple expressions and we don't have to adopt a uniform world view on these things. This is definitely a step back from equality, as opposition Sean Mockey from Victorian Gay and Lesbian Rights Lobby states, "It's a great shame certain faith-based organizations will be able to turn away lesbian, gay, trans and intersex couples based purely on who they are." Though the approval of same-sex adoption may be an exciting victory for the LGBT community, description lies as a huge barrier still for same-sex couples throughout the states of Australia. Due to weaknesses seen in current family laws, it is without a doubt reforms must be made in order to successfully practice the notion of same-sex adoption in Australia. It is recommended for the federal court to re-evaluate the Equal Opportunity Act 2010 and remove exemptions made towards the LGBT community. The court must reject appeals made to deny services to potential parents in relation to their gender identity and sexual orientation. This will make certain that opposite-sex couples are not prioritized over same-sex couples, ensuring only those couples who fit the correct criteria have the right to apply for adoption of a child. Under the Australian Human Rights Commission Amendment 2012 and Sex Discrimination Amendment 2011, the law must enforce punishments and fines across Australian agencies that may deny or show unfair biasness towards same-sex couples, consequently discouraging any discrimination within Australia and encouraging more same-sex couples to become potential parents of adoption. Another recommendation is to make same-sex adoption less restrictive and more effective, deterring couples from seeking overseas adoptions, which are often fraught with cross-jurisdictional problems. This is done by reducing the complexities and rigorous process when facing adoption. This can be achieved by having all states of Australia agree upon one legislation rather than having their own individual policies. This way, limitations and barriers to couples living in different states can be removed, further encouraging couples to become potential parents. In creating a unified adoption law, same-sex couples are ultimately given a higher and more equal chance in becoming parents. In conclusion, there is without a doubt that there are current issues and flaws within our family law when dealing with the idea of same-sex adoption. Its laws recognize the idea, however does not enforce the correct standard to ensure the rights of all stakeholders are balanced correctly. Current laws is slack in assisting same-sex couples who wish to adopt undermining the importance of discrimination within Australia. Hence, it is necessary for Australia's court to reform current legislation in order to protect the interests of the LGBT community. This is to ensure that current family law successfully upholds the rights and obligations that apply to family members across Australia.